We're now moving to the fourth section of the course, and this one involves the Supreme Court and the federal judiciary, the third and really the least visible branch of the national government. I hope you recall from your readings in the Federalist Papers that the founders saw the judiciary as the least consequential or dangerous segment of this new government they were creating. It would really just be an arbitrating body, settling disputes among the states and on occasion interpreting the laws that Congress actually produces. As it's turned out, though, the court has been a very influential factor in our national life, particularly in the beginning of the 20th century, but then increasing in importance over time. Now, this is a picture of the current members of the court. The newest justices include Sonia Sotomayor, who's standing on the left of the photo, and then Elena Kagan, who's standing on the right. These are both President Obama's appointments to the court. In the middle of the seated row in the front is Chief Justice John Roberts, who was appointed to that position by President George W. Bush. And as we'll see, the Chief Justice gets a lot of our attention over time because that person essentially directs the work of the Supreme Court. Now, the court has been quite divided for years, with four fairly conservative justices, four fairly liberal justices, and one swing voter. The swing voter is the late Ronald Reagan appointee Anthony Kennedy, who's seated second from right in this picture. By the way, Justice Kennedy's picture was recently on the cover of Time magazine, and he was described in the caption under his face as the decider. And they gave him that moniker because of the fact that in lots of decisions that are involving contentious political issues, such as the one over President Obama's health reform law, he's likely to come down to be the swing voter in that particular case. We'll take a look at the court primarily through former Chief Justice William Rehnquist's history of that institution, which he wrote around 1970, really in the years just before he was appointed to the court by President Nixon. This book does not deal with a number of important cases that have come along in the last 40 years since he joined the court. It's really been a long custom for sitting justices not to talk or write much about the individual cases in which they've been involved. So I'll deal in some of these PowerPoint presentations with some of the more important recent cases, and we'll do this in next week's clips. Nevertheless, this book seems to me the clearest and best historical overview of the court's role in recent American political life, or at least up until around 40 years ago. So that's why I continue using it in this class. Just by way of brief review, in the first section of the course, we noted that one of the major weaknesses of the Articles of Confederation was that there was no court system at all in place. There was rather a committee of Congress designated to settle disputes that would arise among the states. So Article 3 of the Constitution was written to address this particular deficiency. And I hope you recall that that section created a Supreme Court and gave it a number of different duties. And then the Constitution just left it up to the court and Congress collectively to expand the judicial system as necessary to meet the needs of the growing republic. So I've got a number of the specific duties of the court that are listed on this particular slide. Now, one of the key things to keep in mind about the Supreme Court is that it is an appellate court or an appeals court, which means that it only hears cases that originate in lower courts. The process of a case being decided in a lower court and then being appealed all the way up to the Supreme Court usually takes several years to unfold. And what this meant was that for the first several years of the Republic under the Constitution, there was relatively little for the court to do. Also keep in mind that the U.S. didn't really begin behaving like one nation rather than an agglomeration of separate, largely autonomous states until after the Civil War. So the caseload didn't really begin to be too heavy for the existing court until the late 19th century. So in 1891, Congress created a new layer of courts, the Federal Courts of Appeals, and that's really helped ensure that there were enough judges and courts to handle the issues of concern to the federal government. One of the nice things about the Rehnquist book is his description of the process by which a case actually comes to the court and then is argued and decided, argued in front of the justices and decided by them. There are actually several thousand cases that are appealed to the court each year through the so-called certiorari process, or what we call the CERT process for short. But the court only agrees to hear about 100 of them over any given court term. So it's really quite amazing that a particular case makes it to the Supreme Court at all. Over the next few weeks, we'll talk quite a bit about some of the informal processes the court members use in deciding which cases to hear. And next, I'll turn to some specific early cases that were of importance to the shape of the new nation and the judicial branch of government.